It's 12 o'clock on Tuesday, February the 7th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Campbell, Davis, Gillespie, Hardaway, Howell, Halsey, Johnson, Lamberth, Moody, Russell, Sherrill, Towns, Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, are there any personal orders before we begin this committee meeting this morning? Oh, Representative Moody, you're recognized.
Well, I see in the audience a friend of mine. Now, he is from Shelby County. But Lee Mills, will you wave at everybody? He's active in politics. He's a pilot. He's a lot of things. So we're glad to have you in the audience.
Representative Hardaway.
Thank you, Mr. Chairman. And I have in the audience Delta Sigma Theta women. In fact, if you recall, our own Representative Johnny Turner is a Delta, and she's actually up here with the sorority, and they've got their day on the Hill and their social action going. And trust me, these professional women do good work in the community, not just volunteering, but making sure that they address all of the determinants of quality of life in our community. So if y'all thank them once again for the work they do.
Leader Lamberth.
Thank you, Mr. Chairman, and I appreciate my friend from Shelby County recognizing the Deltas that are in the audience today, but those Deltas are from Sumner County. And so if you're wondering why they're so phenomenal, thank you, ladies.
Any other members? Chairman Howe.
Thank you, Mr. Chairman. I just looked out in the audience and saw most of you have not been introduced to my intern. Paulo, raise your hand. Paulo Santiago, welcome her.
Anyone else? Representative Hardaway.
Thank you, Mr. Chairman. Delta Sigma Theta love is universal.
Well, thank you for that. Oftentimes, well, I don't know how often it happens, but if a newspaper prints something that is incorrect, they will do what is called a retraction. And last week, in introductions of this committee, I horribly mispronounced a young lady's name from the clerk's office. And so I have been practicing for 7 days now, en route to the General Assembly and en route home, saying her name multiple times just to get it right. Miss Alexa Anjay from the clerk's office, everyone. And now for our weekly words of wisdom from our Sergeant of Arms, Mr. Tyler Muniz.
Good morning, everyone. Today's words of wisdom are brought to you by none other than Dolly Parton herself. If you don't like the road you're walking, start paving another one. Thank you.
Thank you for that. Chairman Howe.
I unfortunately overlooked a very special guest in the audience today, my own Attorney General, District Attorney General Steve Crump. Please make him welcome.
All right, committee members, we are set to begin on our calendar for today. If you will, go with me to item number 2. Item number 2, House Bill 281 by Representative Baum will be rolled 1 week. Brings us to item number 1, House Bill 128 by Representative Garrett. You are recognized for brief comments.
Thank you, Mr. Chairman. I didn't realize how fun your committee was. It's been an enjoyment so far. I'll try to make this as brief as possible. This comes from our unbeloved Comptroller's Office, Mr. Mumpower. This extends the statute of limitations from 2 years to 6 years for public officials that create some sort of malfeasance with their office. They steal taxpayer dollars, et cetera. The purpose of this legislation is sometimes their term can be too long and they can cover up their misdeeds and the statute runs. So with the 6-year statute of limitations, we need to preserve those tax dollars and prosecute officials that perform misconduct in their office. So that's what this legislation does. I'd be happy to take any questions the committee may have. Otherwise, let's get a move on.
Well, thank you for that explanation. Members, are there any questions for the sponsor of this bill? Leader Lambert.
I just wanted to share with the good gentleman from Sumner County that most of the folks that present before this committee always think we're fun at the beginning of their bills. Not as many of them toward the end find us as fun, but I hope your bill goes well today. Thank you, sir.
I can't imagine that be the case, Leader. Can't imagine.
Any other questions or comments? Seeing none, we're now voting on sending House Bill 128 on to full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you, Mr. Chairman, committee.
Thank you so much. Item number 3, House Bill 548 by Representative Harris. You are properly recognized.
Thank you, Mr. Chairman, and to the committee. This is a very exciting committee to be in front of. It's better than going to the Six Flags, so I'm excited to be here. House Bill 548 would make it an offense to possess a device that is capable of programming a smart key or key fob with the intent to use it or allow it to be used to commit theft. Tennessee ranks number 1 in vehicle gun thefts nationwide. 8,528 vehicles were reported stolen in Memphis in 2022. UT Knoxville's campus had over 200 incidents reported of burglary or theft involving a vehicle in 2022. Brentwood, Tennessee police have recently reported and been warning residents to be mindful of overnight car burglaries and thefts where 20 vehicles were targeted. Of all of these theft issues across the state of Tennessee, they all involve vehicles, and many of them are theft by a device like the ones that you'll see here shortly. The criminals in these situations have gotten smart and are moving from using the window punch tool that many of you are familiar with that is used by firefighters and emergency personnel to using key fob devices that detect transmission from one person to another, and they're called relay devices, radar devices, and transmitter devices. These devices have been around for years, but only in recent years have thieves been able to get a hold of them, often from a manufacturer or car dealership, to commit theft and burglaries. In most situations, like the ones in the photos, while one thief has a key fob-like device in one hand, another thief will stand within range of your vehicle or wherever you may be located and pick up the frequency from your actual key fob that is in your possession and use the signal to feed it back to the device to unlock your vehicle without your permission or without your knowledge. While theft is a crime, this specific section will put thieves on notice that people are aware of what they are doing and that if they continue doing this, they will be found in violation of the law when they are caught. Hopefully, this will deter future vehicle thefts even just a little. I hope that I can count on your support to move this forward with a positive vote. Thank you, Mr. Chairman.
Thank you for that explanation. Any questions, comments for the sponsor on this bill? Representative Moody.
Thank you, Representative Harrison. We spoke last night, so for the benefit of the committee, he was telling me about the bill, and I was telling him that I had a constituent who, before COVID, was at a mall in Memphis and had things in the car, but they were hidden, went into shop, came out, and noticed everything was out, gone, but no windows broken, nothing happened. And so the key fob incident came up that it does seem to be that technology can override it. And so one thing, I don't know if you were able to get the answer, but just for people to think, she was told that if she didn't use the key fob but locked her door from inside the car, that that was better than using the key fob. So I do have a constituent that's gone through this, and if you know the answer yet, I'm just curious, but thank you.
So no, the chief of police wasn't able to give me a direct answer to that question specifically last night. But of course, I also went through something similar to that as well. I was at an event, and you can see from the camera, watching it from the video, where two gentlemen jumped out. One stood closer to the building where they knew I was in, and the other one stood by the car, and they transmitted. They were able to unlock the vehicle. They thought maybe they would find a gun. They didn't take anything else, but it does happen. And so the chief, the police department did mention that this is just something that is becoming common now, where they are using it to get into the vehicles. And so we're seeing that rise happen. And while we can do something about it, I'm trying to see what that looks like. So thank you.
Thank you.
Representative Johnson.
The relay device, what size is that? Is it like handheld? Sorry, Mr. Chairman, thank you. I'm curious just the size. Is it easily handheld? Is it very visible, the size of it?
So from looking at different devices, there are multiple different versions of it, and they come from either the manufacturer or you can get it from the car dealership, but they are some that are handheld. There are some that are coming like a battery size that unfortunately it would be heavy for somebody to carry, but some are larger and some are smaller. Some actually have a key fob that looks just like your key fob. They put into another device and it will help transmit from there.
Any other questions? I do have one question. Under this proposal, the pictures and videos that we've seen, it takes two people. If one person has one part or a component of the complete setup, would they be in violation of this law underneath this?
Yes, Chairman, based off of this, it says if you possess a device or part of the tool, then you would be in violation and in parts of this offense.
Excellent. Thank you so much. Any other questions for the sponsor? Thank you very much. Questions called. We're now voting to send House Bill 548 on the full criminal. Those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you, Chairman, and thank you to the committee.
Item number 4, House Bill 413 by Leader Lamberth. You are properly recognized.
Thank you, Mr. Chairman, members of the committee. This is a very simple bill. It allows for law enforcement service to count towards someone's eligibility to become a probation officer. We already have educational attainment and military service as part of it. This just adds law enforcement service as well.
Thank you for that explanation. Any questions? Comments? Questions called? No objection. We're voting to send House Bill 413 on the full criminal. Those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal. Item number 5, House Bill 450 by Leader Lamberth. Second. You're properly recognized.
Thank you, Mr. Chairman, members of the committee. Again, this is literally a cleanup bill. The TBI noticed in the statute there is nothing that allows them to give a certificate of eligibility to the individual that actually pays for it. So someone who's never committed a crime before, they pay $100, go on the TBI website, they fill out a form to determine whether or not they're diversion eligible. For years, the whole time we've been doing this, to the best of my knowledge, that goes to the defendant or their attorney. Unfortunately, the statute indicates that it would go to the judge or district attorney. So we're adding in defendant or defendant's counsel to that list. They're the folks that are filling the form out. They're the ones that need to know whether they're diversion eligible. Obviously, the judge and the DA need to know as well. But first and foremost, the individual paying for it needs to know. So that's what it adds to this.
Any questions for the sponsor? Comments? Seeing none, we're voting on sending House Bill 450 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal. Item number 6, House Bill 385 by Leader Lamberth. You are properly recognized.
Thank you, Mr. Chairman, members of the committee. I want to commend our full committee chairman, Chairman Halsey. Before he was the full committee chairman of criminal justice, he conducted a series of hearings over the summer after some absolute tragic and horrific crimes that occurred really in Memphis, and then it brought to light quite a bit of issues across the state when it comes to pretrial jail credits. Right now, if an individual is serving pretrial time before they are convicted, that individual gets that time on their judgment. And so if they get a year, the assumption would be they get a year of served time. I mean, they served 1 year. They obviously have a right to that. Unfortunately, the statute says that they also automatically get good time and behavior credit. Automatically. There's no evaluation done or anything. Unless the sheriff were to say, no, that person's been horrendous enough, they shouldn't get it. This bill flips that on its head and just says that the sheriff has to make the determination and send that to TDOC as to whether or not that person would get good time. It's not an automatic decision. It should be a very purposeful decision. My hope is this will help folks behave during their pretrial term. They'll know that they have to behave in order to be able to get that pretrial good time credit. Again, they absolutely are still eligible for it, but it's just not an automatic decision.
Thank you for that explanation. Representative Gillespie.
Thank you, Mr. Chairman. Leader, I just want to say thank you. This is a really good bill. It'll really help the people in my district and the greater Memphis area. So I just wanted to publicly thank you.
Thank you for that. Any other comments or questions for the sponsor?
Question on the bill.
All right. Representative Russell.
Thank you, Mr. Chairman. And I may have missed it. Did you say that credits can be taken away for bad behavior too?
Thank you, Mr. Chairman. Absolutely. I mean, the determination is made. So, I mean, if they earn the credits, they get the credits. If they don't, they don't. I mean, it's just a communication between the Sheriff's Department and TDOC. But right now, that communication is just really not happening. And so the determination would be made by the sheriff. And if they've earned them, then they could be granted them. And while they're in their pretrial credit, I'm sure each sheriff will have a process as to how they want to either award those or not.
And what if they have like 100 credits? Can they get like 10 taken away for bad behavior?
I see no reason why they wouldn't be able to. Again, it will be up to the sheriff to determine that good time credit and communicate that to TDOC.
Very good.
Any other questions? Seeing none, we're now, voting to send House Bill 385 on the full criminal. All those in favor say aye. Aye. Those opposed, ayes prevail. You move on. Item number 7, House Bill 412 by Leader Lambert.
Motion. Second.
You're recognized.
Thank you, Mr. Chairman, members of the committee. I didn't anticipate having so many cleanup bills this year, but this is another one where implied consent charges are when someone is arrested for DUI and then declines to take a blood or a breath test. They're charged with implied consent. In most circumstances, those are actually not criminal matters. They're administrative in nature and or civil. It's kind of a quasi-administrative / civil proceeding, but it is merely for the determination as to whether or not their license will be revoked for a year. When those are dismissed, if they had gone into the TBI at some juncture, there needs to be a process that those can be expunged off someone's record. If it's truly dismissed, and I mean dismissed, without cost. I mean, it is a true dismissal where that nobody was given a favor on that. Nobody was, hey, it was dismissed because they're just being nice to somebody. It's dismissed because they were not guilty of it. This creates a process so that they can do what everybody else can do when a charge is dismissed, so they can actually get that expunged off their record.
Thank you for that. Any questions for the sponsor? We do have testimony. Seeing none, we'll go out of session. Hear from Department of Safety, if you will. Introduce yourself, who you represent. You'll have 3 minutes for remarks.
Elizabeth Stroker, Legislative Director for the Department of Safety, and I'll be brief. Thank you, Leader Lambert, for meeting with us on this one. We have a really weird little nuance of we need to make sure that the implied consent citation is an actual dismissal, like you said, and not one with cost, because if it is with cost, it's still a conviction, which can then be in violation of federal regs and put TDOT's road money at risk. So we've got an amendment drafted that we've shared with him. I just got word from FMCSA that they think it looks fine, but their attorney is not in until 8 a.m. tomorrow, and then she will review it and give it the all clear. But assuming that amendment it gets amended in the next committee, if y'all choose to move it on, we're comfortable knowing that that language can get changed pretty quickly.
Representative Russell.
So I got a question. I don't know if it's for safety or the leader, but if it's dismissed and the person has to pay litigation taxes, how would that?
I don't know the answer to that. That may be a court question. I don't know how they handle fees and what fees get paid for citations. That's a good question.
I've seen it happen before in courts. That's why I was asking. So thank you.
Any other questions for our guest? Seeing none, we'll go back into session. Leader Lamberth.
Thank you, Mr. Chairman. And I had filed a late filed amendment with the committee just with the words without cost. I mean, the intention obviously is without cost. There's no cost associated with most of these, either court litigation taxes or others. And implied consent, unless it matches up with another charge, shouldn't have any cost, fines, fees, or anything associated with it. Again, it's an administrative finding. And so these should not. Now, in the rare occurrence where they might, in adding the words without cost, I think there's a chance that some of those folks, even if it's taxes, litigation taxes, anything, could potentially keep them from getting it expunged. And that's something that they really need to take into account, either they or their attorney is working through the criminal justice process. If they want to try to get it expunged, my recommendation would be that it be truly without any cost. And I think that makes sure that we don't run afoul of any federal issue or anything else. I have reached out to some of our federal counterparts to ensure that resolves any issue. It seems pretty bizarre to me that if a case is dismissed, that somebody couldn't get it expunged. It's dismissed. You're innocent until proven guilty. If the state didn't prove you guilty, you should be able to get an expungement. But we're working through that.
I agree. I think it's a great bill. I'm going to be voting for it. And I think that if we don't do this, some people's going to not be able to get a job because it's going to be on their record. So, good bill.
Thank you, sir.
Thank you, Representative Hardaway.
Thank you. And to the sponsor, I'm not sure if I'm clear. The without cost amendment will take into account the issue that the Department of Safety had with the bill? And you're putting it on as an oral amendment, or what are we doing?
Thank you. So again, dismissed, there are other sections of the code. I know safety's worked on this for years. If something is dismissed and it's dismissed with cost, for purposes of their system, it's not really dismissed. That's called masking on the federal level. And so the intention of this bill is for that it's dismissed without cost. I don't mind putting those two extra words in there. Again, the amendment was not filed in time for this particular committee. My understanding, and this would be more to the chairman, but my understanding from the chairman's perspective is that he would prefer we not deal with the technical change like that at this level. But the intention is dismissed without cost. Whether the words are on the page or not, a true dismissal is dismissed without cost.
All right. Thank you. Thank you, Chairman.
Thank you. Any other questions or comments for our sponsor? Seeing none, we're now voting to send House Bill 412 on the full criminal. Those in favor say aye.
Aye.
Those opposed, the ayes prevail. You move on to full criminal.
Thank you, Mr. Chairman, members of the committee.
And now I will hand this gavel down to my senior partner, Chairman Hulsey. I called him senior.
You're just mincing words. I was born back when the Dead Sea was just sick, but you don't got to rub it in, son. Okay, we're now on item number 8, House Bill 701 by Chairman Doggett. You're recognized, sir.
Motion.
Second.
Well, thank you. What this bill does, it expands the offense of solicitation of a minor to include statutory rape by an authority figure. It also requires that a person convicted of continuous sexual abuse of a child be sentenced to community supervision for life. And I do, Mr. Chairman, have someone here that would be available for questions or testimony.
That's fine. Are you requesting the testimony? Mm-hmm. We'll go out of session. Please come forward. Please state your name and who you're with for the record.
Yes, sir.
Good afternoon. Kim Helper, the elected district attorney for the 21st Judicial District, which comprises Williamson County. This bill really is just sort of a cleanup or a housekeeping bill. The first part of it regarding statutory rape by an authority figure. Right now, TCA 13528 lists various offenses for which someone can be held accountable for soliciting a minor to engage in wrongful conduct. And what's missing from that list is the statutory rape by an authority figure. So this just adds that offense into that list that's encompassed under that statute. The second part is really just more for consistency. Right now, a continuous child sexual abuse offense is listed as requiring community supervision for life once the incarceration is complete, and that's in TCA 4035-501L2. This basically just adds it as well in 3913-524, so it's consistent.
Okay, thank you. Any questions from the committee for the witness? Seeing none, we'll go. I appreciate that very much. We'll go back in session. Any other questions for the sponsor of the bill? Questions been called on the bill. We're voting now on House Bill 701. All those in favor say aye.
Aye. Aye.
All opposed, no. Bill passes to full committee.
Thank you, Chairman and committee.
The next and last bill on the calendar is House Bill 705 by Chairman Doggett as well. Chairman, you recognize.
Motion.
Thank you, Mr. Chairman. What this bill does, it's really a cleanup bill as well. It requires court ordering the expunction of a person's public records of criminal offense to include the appropriate state control number in the copy of the expunction order that's sent to the Tennessee Bureau of Investigation.
Okay, that's start to say an example. That is a demonstration well done for this bill.
Why, thank you.
Any questions for the sponsor? Yes, sir. Leader Lambert, you're recognized.
Thank you, Mr. Chairman. And just to get to the intent of this, so if for some reason in the rare circumstance where that number is not available and the TBI were to receive an application for expungement and that number is missing, is there any prohibition against them still processing that form? I know the law will say that it absolutely has to have it, but is there any punishment or recourse or anything that would keep them from using their discretion to make that decision?
Let's see. I believe that they would still process that in the event that the control number is not there, but it would help with record keeping and everything else that they're doing already. There's already a control number on the judgments, a state control number there. So by putting on the expunction application so that they can have that, it just kind of keeps everything in line and order.
Yes, sir. Leader, you're recognized.
Thank you, Mr. Chairman. And I hope that everybody would follow this law, very closely, but I also trust the folks over the expungement division to do that. And I'll make my now annual plea for all of us to please get them some additional funding. The folks that work in the expungement unit over there absolutely work their tails off. And it's changing lives every day when they take something off somebody's criminal history that should not be there and that they have a right to get off. But they sure have a lot of workload right now. So we should get them all the help we can. Thank you, Chairman.
You and I also, Chairman, received a note from Hamilton County on the clerk's office there that sometimes if it's not included with it, it very well may slow down this process. And
yes, sir.
Any other questions for the sponsor of the bill? All right, we're fixing to vote here on House Bill 705. All those in favor say aye.
Aye.
All opposed, no. Bill passes to full committee.
You want to take us home, Chairman? Or should I close it?
We'll just do it. We'll just do it. Is there any other business for the committee before I entertain a motion to adjourn? Motion to adjourn. All those in favor say aye.
Aye.
We are adjourned.